So authorized representative essentially is the AR that has been appointed by the company or by that particular entity to represent that entity. It can be through a board resolution, it can be through any other authority letter, depending on what that entity is. A constituted attorney, on the other hand, is somebody who has the power of attorney, which can be a special power of attorney, it can be a general power of attorney, and it can also be a wakalatnama. So, constituted attorney essentially has the authority or the power to act exactly like the person who has granted that SP or the GPA would. So, it is a principal agent relationship that happens. And jahan par that principal grants the agent to step in the shoes of the principal, and they have more powers to act exactly as the principal. Whereas AR is for that particular purpose, जिसके लिए फॉर एग्जाम्पल अगर मैंने मेरी एक कंपनी है ABC लिमिटेड, एंड मैंने वो जो कंपनी है उसमें AR अपॉइंट कर दिया यशोधरा को, तो AR को मैंने बोल दिया कि दिस AR कैन फाइल दिस केस ऑन माय बिहाफ, इट कैन on behalf of the company, and she can sign the plaint and she can sign the evidence and so on and so forth. तो मैंने स्पेसिफाई कर दिया और वहां पे AR की एक लिमिटेड रिस्पॉन्सिबिलिटी आ गई, जहां पर AR अगर साइन कर रहा है वो पर्टिकुलर चीज है, देन AR के पास वो पावर है। जहां पर मैं जनरल पावर ऑफ अटॉर्नी दे देती हूँ यशोधरा को, यूजुअली पावर ऑफ अटॉर्नी इंडिविजुअल्स देते हैं। ओके, सो पावर ऑफ अटॉर्नी जहां पे मैं दे देती हूँ, देन यशोधरा कैन step into my shoes and act on my behalf as if I have done those acts. So whatever she does, I am bound by that. And that is generally more enhanced and more advanced as compared to just an AR or an authorized representative. The AR can change constantly. GPA, SPA में आपको उसको कैंसिल कराना पड़ता है। और अगर वकालतनामा है फॉर एग्जांपल, तो वहां पे कॉन्स्टिट्यूटेड अटॉर्नी जो होते हैं वो आपके लीगल रिप्रेजेंटेटिव्स बनते हैं, वो आपके लॉयर्स होते हैं। आपके लॉयर्स के पास भी पावर है कि वो कोर्ट में जाके जो भी करेंगे, यू आर बाउंड बाय दैट इफ यू हैव साइंड द वकालतनामा। And GPA is broader than special power of attorney. Special power of attorney can be limited to just a few acts, but at the same time, there is an assumption that जिसने भी वो power of attorney दिया है, that person has given the permission to the constituted attorney to do anything that is noted down in that particular document on behalf of the uh, main person, on behalf of the principal. So I hope that clarifies it. Although it can be a confusing, uh, topic.
I got it.
Great. So now, before we go on to the rest of your questions, जैसे मैंने आपको वो draft दिखाया था in the beginning, now I'm going to show you another draft, and this draft is some. Okay, मैं आपको ज्यादा नहीं बोलूंगी उसके बारे में. I want your honest opinions on it. But you saw that draft that was for trademark infringement, and now you're going to see another draft, and this one is also for trademark infringement. So as you can see, I hope you can see on your screens, this has been filed in the US, and this is a very, very famous case. This has been filed against the X mark that is being used by Twitter now. So there is a company called X Social Media LLC, and they were using the X mark, and now they filed a case against Twitter, जिसमें वो बोल रहे हैं that इन्होंने हमारे मार्क को इन्फ्रिंज किया है. Now just see how this has been drafted, okay? सबसे पहले ऊपर कोर्ट का नाम आया, सिविल एक्शन नंबर, वो लोग थोड़ी टर्मिनोलॉजी डिफर करती है वहां पर, बट जस्ट सी हाउ इट इज स्ट्रक्चर्ड. So here this is the complainant. कंप्लेनेंट के बिहाफ पे ये फाइल हुआ है, तो यहाँ कंप्लेनेंट लिखा है, कंप्लेंट लिखा है. देन प्लेंटिफ है और डिफेंडेंट है. देन उसके बाद प्लेंटिफ एक्स सोशल मीडिया बाय एंड थ्रू इट्स अटॉर्नीज अलेजेस एज फॉलोज. सबसे पहले नेचर ऑफ एक्शन, तो सब्जेक्ट मैटर हम लिखते हैं, वो इन्होंने नेचर ऑफ एक्शन लिखा है. देन वी गो ऑन टू द पार्टीज, देन दे आर डिस्क्राइबिंग द पार्टीज. And don't worry, I'm going to share this also with you, so you can just take a look at it in a relaxed manner at your own pace. But I just want you to notice these tiny details. Then they have talked about jurisdiction and venue right in the beginning. They are explaining to the court how the court has jurisdiction and venue, because that becomes the most important aspect that has to be looked at by the court before they can even enter into the merits of the case. So then they are saying that, okay, this court does have jurisdiction. How does it have jurisdiction? They've given these paragraphs to define that, to describe that, to explain that, justify that. And then they talk about background facts. Then they're giving the chronology of facts. Okay. एंड देन दे आर टॉकिंग अबाउट मार्क्स. यहाँ पर हम जब अपने प्लीडिंग्स में कोई डॉक्यूमेंट मेंशन करते हैं, हम उसको अनेक्शर बनाते हैं, एग्जिबिट हम बनाते हैं एट द स्टेज ऑफ एविडेंस. एंड बट इन सम कोर्ट्स, इन सम हाई कोर्ट्स एंड इन फॉरेन कोर्ट्स, यूजुअली वो लोग एग्जिबिट करते हैं अपने डॉक्यूमेंट्स को एट द टाइम ऑफ फाइलिंग ऑफ द सूट itself. So that is also one difference जहाँ पे इन्होंने एग्जिबिट किया हुआ है. देन अनलॉफुल इन्फ्रिंजिंग यूज ऑफ द एक्स मार्क कैसे है, उन्होंने इसको इन पैराग्राफ्स में डिफाइन किया है. देन वी गो ऑन टू द नेक्स्ट सब हेडिंग. द they've also given a screenshot of Google search. Then we talk about cause of action. यहाँ पे उन्होंने बताया first cause of action. Brackets में उन्होंने एक line में explain कर दिया what is the first cause of action. Register trademark and service mark infringement. Then they go on to the second cause of action, Florida common law unfair competition. Then they go on to third cause of action, Florida Deceptive and Unfair Trade Practices Act. And then they go to fourth cause of action, which is common law trademark and service mark infringement. Finally, they go for prayer for relief. Wherefore, now wherefore is also a very good way of asking for relief or to use in your prayer clauses. Usually, in Indian drafts, you'll see वो लिखते हैं कि in light of the facts and circumstances, or in the facts and circumstances, or in view of the above, or in view of the foregoing. उन सब से काफी better है अगर आप ये term use करो जो usually आपको foreign drafts में मिलेंगे. Wherefore, plaintiff requests judgment in its favor against defendant as follows, and then they have asked for these reliefs in the prayer clause. Now, end में उन्होंने डेट लिखी है, उन्होंने रिस्पेक्टफुली सबमिटेड, देन उन्होंने प्लेंटिफ का नाम लिखा है, और उन्होंने फिर बताया किसने ये ड्राफ्ट किया है, कौन इनके अटर्नीज हैं, कौन इनके एडवोकेट्स हैं, एंड देन देव गिवन अ सर्टिफिकेट ऑफ सर्विस. नाउ I want to ask you, now that you've seen this draft, what difference have you noticed in the draft that we saw right in the beginning of the session and in the draft that we saw just now? What is the broad difference that you've noticed in these drafts? And yes, you can tell. It's very much clear. It's not just the presentation or the way it's written or the clarity. It is there is a very visible difference. I would like you to share what your opinion is. So yes, Yashudra.
So I thought that the so I thought that the foreign draft was a lot more structured than like the Indian drafts are. I mean, if like territorial jurisdiction, call of action, and limitation are like the most three important ingredients that we have to, inculcate in the draft, and that is what the judge looks at before discussing the merits of the case. Then obviously that should come like on the top after like the cause of action or the subject matter thing. And baki the like facts can also like uh, succeed the cause of action, jurisdiction, and limitation thing. And also I thought that they were more crisp in their language. They weren't using like they weren't as a writing lengths in their drafts. They were like precise in what the facts were and what they wanted out of the filing of the suit or in the draft. And they had not like included like everything. I mean, like Indian drafts do include like everything. Like they don't see what the uh, the sections are. Like they include all of the sections. So, for example, if you are talking about section 57 or section 57 of the Indian Trademarks Act, which talks about the cancellation of cancellation petitions, then you like then there are, I have seen drafts which include like all the subsections of section 57, where only section 57 subclause 1 or subclause 2 comes into the picture, but you include any and every other section.
And you
So that is
reproduce
one
the
thing.
section. You,
Yeah, you
yeah,
reproduce the section in the plaint in the written statement, which according to Order 6 isn't allowed. You cannot include the section. And I have seen a lot of drafts where I have seen in the written statement that they have reproduced those sections, or they have written only those sections in like a separate paragraph,
right,
and which does not make any sense. I mean, you
right,
just have to, in the application you would only write that this is a subject matter of law and statute of interpretations and it deserves no response. So why would you write that in your written statement?
right.
So I mean,
Absolutely. Absolutely. I concur. I wholeheartedly concur. So great. Thank you for sharing your views, Yashodhara. I also want anybody else to share what they saw, what their opinion is, before I also go on to sharing my opinions, why I showed you this particular draft. So, Shraddha, Vaibhav, Yash, Karishma, if you would like to add to what Yashodhara just said. I'm sure, I mean, Yashodhara has covered almost all the points. Okay, you're probably writing in the chat box, so we don't have a lot of time. We've already exceeded our time limit. But let me just leave you with this, that it doesn't matter whether it's a foreign draft or an Indian draft. You do not have to limit or restrict your understanding or your presentation of your case to one particular style only. So there is no hard and fast rule कि आपको ऊपर ये लिखना है, नीचे ये लिखना है. The idea is, पहली बात तो कि structure होना चाहिए. And like Yashodhara said so rightly, that jurisdiction इतना important है, when venue इतना important है, limitation भी important है. जो आपको चीजें कोर्ट को बतानी है, जो आपको पता है कोर्ट विल लुक इनटू फर्स्ट, आपका काम ये है कि आपके ड्राफ्ट से कोर्ट का काम आसान हो जाए. जितना आप उनके लिए कन्वीनियंट करोगे चीजें, उतना बेटर रिस्पॉन्स मिलेगा आपको. नॉट इन टर्म्स ऑफ यू गेटिंग अ जजमेंट इन योर फेवर इफ द लॉ डजंट अप्लाई टू यू, बट in the sense that you will be heard properly and effectively. So, for that, it is important for you to keep your audience in mind, to keep the court in mind when you're drafting, and please use headings and subheadings, and use structured paragraphs. Like Yashodhara just said, that you cannot plead law, so you do not have to explain or justify that okay, ये legal provision है, ये इसका इंटरप्रिटेशन है, ये केस लॉ है, ये ऐसे है, ये वैसे है. जब आप पहली बारी सूट डाल रहे हो, पहली बारी आप सूट फाइल कर रहे हो, आप अपील की बात नहीं कर रहे हो. यू नॉट टॉकिंग अबाउट स्पेशली पिटिशंस, यू नॉट टॉकिंग अबाउट PILs, we are talking about suits. You're filing the suit for the first time. You plead facts. You give your facts. You then explain. जैसे उन्होंने कितना simply, like in one glance, you could see this is the nature of the suit, this is the party, this is party number two, this has been the infringement, this is the background facts. Then you have you have jurisdiction, how the court has jurisdiction and venue, and then eventually, chronology of facts, and then you have first cause of action, second cause of action, third, fourth, and in the end you have the prayer. And simply, briefly, concisely, precisely, you have conveyed your case to the court. That is the idea. And that is why I wanted you to focus. I wanted you to understand that, there are different ways in which you can present your case, and you should do it in the simplest of manners, and जिसको देखकर लगे कि आप उसको पढ़ना चाहते हैं, आप उसको समझना चाहते हैं. Even if you do not get the time to, or you do not get the pages or the words. Places में कोई word limit नहीं होता है जहाँ पे आप सब कुछ लिख दो. आपको यूजुअली ऐसा लगता है कि अगर आप सब कुछ लिख दोगे then कोई ना कोई चीज तो स्टिक कर जाएगी, कोई ना कोई चीज तो आपको मिल जाएगी. बट दैट शुड नॉट बी द अप्रोच इन माय ओपिनियन. यू शुड precisely convey properly in a well articulated manner, in a well structured manner, just exactly how you are planning on convincing the court to grant the relief in your favor. And the more direct you are, the more straight you are, the more brief you are, the more simple you are, the better it will be for your case and for your client. So, with this, we've come to the end of our session today. If there are any final thoughts, final questions, please feel free to ask me those questions either by writing in the chat box or by just unmuting yourself and talking to me. I'm going to stop recording also now so we can have a few minutes to your doubts and your questions. And whatever material I showed you, I will be sharing that material with you over mail, and you will be able to see different kinds of drafts. And if there are any different kinds of, you know, questions, drafting questions, or different kinds of drafts that you want to discuss, please feel free. That's why we are here. My idea, the basic purpose of this particular session was to introduce you to the just the aspect of drafting and how you should approach a draft, how you build it, how you present it, and how it leaves a mark of you is essentially all up to you. Ultimately, when people read your draft, they should be able to tell that it's written by you. You know, you should leave some personality, something that is only yours with that draft. And that is how you know that you are growing, that you are understanding it better. It takes time, you have to be patient, but it has to be you. So, yes.